The Law Offices of Brian J. Smith.
Every day, good and hard workers in Ohio lose their jobs and turn to the Ohio Department of Jobs and Family Services, ODJFS, for the unemployment compensation they deserve to help them while they search for new employment. Employers, on the other hand, frequently set up roadblocks to those benefits in an attempt to keep their unemployment premiums down. If a former employer convinces unemployment that it had just cause to terminate you, or that you lacked just cause to resign if you quit, your claim will be denied. It might also be denied if your former employer failed to properly report your earnings to unemployment. There is an appeal process for unemployment claims that provides opportunities to obtain a determination in your favor if you have an attorney who understands the steps, the laws, the rules, and has the skills to persuade unemployment that you have a right to the benefits. Unemployment does not operate on what you know to be true unless that truth can be shown to them, proven to them, and explained in a way that they will understand that Ohio's laws and rules require them to pay your benefits. The steps to obtain your benefits begins with your application, after which your former employer will be notified and given an opportunity to respond. A caseworker with Jobs and Family Services, ODJFS, will investigate the claim and make an initial determination about your eligibility, after which either you or the employer may file an appeal in writing. The importance of this first appeal step lies in the need to get the benefits started for you as soon as possible. Once ODJFS reviews that appeal and makes a decision, either party may also appeal that decision. This appeal step, though, becomes the most important because it is the best chance to win the benefits, and in almost all cases it will be the final decision. At this point, the appeal moves from Jobs and Family Services to another agency called the Unemployment Compensation Review Commission, UCRC, who will schedule a hearing, which are almost always done by telephone. These hearings are scheduled for 45 minutes, and the hearing officers do push hard to get them completed during that 45 minutes. Therefore, it's important to be prepared for the hearing and focused on what are the most important points to be made and the best way to make those in a way to convince the hearing officer that you are entitled to your benefits. These hearings bring with them the opportunity to obtain a full copy of your file, which includes whatever the employer turned in to support their case, as well as the opportunity to subpoena documents from the employer and to submit your own exhibits. Although this hearing officer's decision can be appealed one more time with the UCRC, and even later at court, they won't hold new hearings. Rather, they will rely on what is already in the record at the time of the hearing, and in all likelihood, they will defer to whatever the hearing officer decided.
The unemployment appeal attorneys at Smith's Law Offices have the expertise and experience to navigate through the unemployment appeal process to present the best case possible to obtain the benefits you deserve. This is most often done with no upfront legal fees, getting paid only when you get paid. The attorneys at Smith's Law Offices provide personalized representation, valued for their experience and respected for their skills. If you find yourself in need of an attorney, contact us for a free telephone consultation at 800-641-1970.